Good afternoon, everyone. My name is Adam Crowell. I'm President and General Counsel of ComplyNet. We're going to be talking about OSHA today. And if you know about recording and reporting and all the differences between those, and you know about safety data sheets and HAZCOM and right to know sort of training, you probably don't need to be sitting in here. But if you need to know about the important things and the important aspects of OSHA, you found the right place, because we're going to cover a lot of ground. And first off, let's just start off with what is OSHA. OSHA is the Occupational Safety and Health Administration, been around since the 70s. And OSHA's claim to fame is that since its inception, it has had the teeth to be able to get workplace deaths down to about half of where they were before its inception per employee. So just imagine that. They have managed to be able to make the workplaces that much more safe across America, and their goal is to keep that number very, very low. So why do you need to worry about OSHA as a dealership? Well, first of all, dealerships are not exempt from OSHA. As a dealership, you have an obligation to make sure that your employees have a safe working environment. OSHA has jurisdiction over 8 million work sites, pretty much every industry in America. Their annual budget is $557 million. They have over 2,100 inspectors nationally. That's on both the state and the federal level. They conduct anywhere between 70,000 to 100,000 inspections per year. Last year, they were around 77,000 inspections that they had conducted. They have the ability to fine you up to $132,000 for a single violation. And there have been plenty of cases where OSHA's actually come in and fined businesses over $10 million. The record is over $60 million. That's for one incident. OSHA also actively refers matters for criminal prosecution. So they're working with the Department of Labor. In fact, they have a written agreement with the Department of Labor. And this written agreement with the Department of Labor and with the Department of Justice requires them to get together, and it requires them to talk about safety issues and talk about some of the bad actors, and it requires them to cross-train each other. And so they're actively getting together on a regular basis, and they're talking about some of the bad actors out there. So one example that I want to talk about here today is a case study. It's called Linway Auto Auction. Some of you may know about this example. It happened a couple years ago. Linway is an auto auction that's out in Massachusetts, and they had a driver that was driving through the auction lane. Something happened. He says that the pedal stuck on the Jeep Cherokee that he was driving. Turns out he did not have a driver's license. He was driving on private property. He also didn't have proper footwear. May have played a role in that. But his foot got stuck on the accelerator. The accelerator kept going, and he's tearing through the auction lanes. And for those of you that have been to the auctions, you know it's kind of a hectic, chaotic sort of place. He tries to veer off to hit as few people as possible. Witnesses say that the bodies were flying. Okay, 2 people instantly die. Another person, they're trying to resuscitate through mouth to mouth. She dies right away. 2 other people die later. A total of 9 people were ultimately injured. So in that case, Linway Auto Auction, one of the things that you need to know about them is OSHA had inspected them before due to a prior incident. One of the suggestions that OSHA had made and that Linway had agreed to was that they were going to put up certain barriers to kind of stop the cars from potentially hitting pedestrians in the auction lanes. They agreed to that. They didn't fight it. But because of that, they now had an agreement with OSHA that they were going to fix the problems. They didn't fix the problems, and now you result in 5 fatalities. So there was civil exposure that happened to Linway. Originally, they were cited for $267,000 in civil penalties. They settled it for $200,000. They also agreed to finally do all the stuff that they said that they were going to do before, which was install barriers, crosswalks, other safety measures. But more importantly, there was criminal exposure. The owner, who's now the former owner, because they had to sell the auction, he's now under indictment for 5 counts of manslaughter. See, he had signed that agreement with OSHA that he was going to correct these issues. He's 70-some years old. He's been forced to basically sell the auction at this point. He faces up to 100 years imprisonment. He was just indicted this past March. Company's also under indictment, going to face a fine, but truthfully, the business is done now. The auction's been sold off to another company. So basically, they have lost everything because of this, and the owner is now under indictment for these 5 counts of manslaughter. Will he do time? I think he's going to end up doing some time. How much time? That's the real question, but it's really not looking good at this point. On top of that, think about whenever you have an injury that happens at work, you have workers' comp claims, right? And usually workers' comp claims are the sole remedy for an injured worker. Well, because of the fact that OSHA was on site before and you had these other injuries that happened, now the plaintiff's attorneys are saying, hey, this goes beyond just negligence. We're talking about some sort of intentional conduct or gross negligence. And now they also have wrongful death lawsuits that are out there. So now there's potentially even a double exposure related to that. The one thing that I would say about that is I really hope that they had really good insurance policies that were in place. I guarantee that they weren't really leveraging their compliance program, because otherwise they would have probably taken the proper actions to make sure this wasn't happening again. And if they would have done that, they could have probably saved lives. They could have also saved money on their insurance premiums if they were doing that. So what you need to know about inspections are that the inspections that OSHA conducts where they come on site, okay, so I mentioned there's 2,100 inspectors, 70 to 100,000 inspections that happen every year. Sometimes they have a targeted program. They're selecting certain industries and certain businesses where they think that there's a greater risk of injury to the workers. 86%, however, are purely reactionary, right? Something has happened. There was an injury. There was a fatality, there was some sort of complaint, there was a referral. And what you really need to know is that 46% of those, so 40% total of all visits that happen from OSHA, it's because you have a disgruntled employee that acted as a whistleblower. So they're calling OSHA and saying, hey, OSHA, I want to be anonymous here, but I want to tell you about what's going on at this place. And that prompts them to come onto your site. So I don't know about any of you, if you have employees that might be disgruntled from time to time. This is the type of stuff that can ultimately happen, which is why it's very important to make sure that you're staying on top of the OSHA regulations. And from a very small business standpoint, if someone does make a complaint, chances are you're probably going to know who it was. You're going to know who that disgruntled employee was. You're going to know that they made the complaint against you. And the whistleblower complaints are increasing, and it's probably because they have more access to more materials. Everything's on social media now. There's a lot of people that are giving their legal opinion, whether they're lawyers or not, right? They're telling them to call OSHA about different things, and that's ultimately happening. So it's increased 29% in 2018. But the other thing that you need to know about whistleblowers is that they're protected. Okay, so you might know that that employee did that. And you might want to get rid of that employee, but if you do, just know that you're going to be subject potentially to additional fines. They might even sue you. They can get lost wages, actually triple their lost wages. They can get attorney's fees. And worst of all, they can get their job back. So you lay them off, and ultimately they're going to come back because you fired a whistleblower, and they have that type of protection. So one of the very first questions that I always ask someone when it comes to OSHA and whether or not they have a compliance program that's in place that meets the OSHA requirements is, was your 300A posted this year? Can I see a show of hands? Who posted their 300A? Okay. Was it signed? Okay, so I'm seeing some nodded heads. Has it been taken down? Okay. So what you need to know about that is that you need to post those from February 1st through May 1st. Okay, they can come down on May 1st. And those 300 days are related to what happened the year before. For those of you that I didn't see any reaction from, do you even know what a 300-day is? Okay, and I'll get into that here in a second. More importantly, do you know the difference between what's a recordable injury and what's a reportable injury? There's a big distinction between those two things. Generally, when it comes to reportable injuries, this is where you have to reach out to OSHA and say, hey, this really bad event just happened. Within 8 hours of a work-related fatality, if the death occurs within 30 days of the incident that happens, you have to contact OSHA. So let's say that something happens on your premises, it's a work-related injury, you have to contact OSHA within 8 hours of that death. If someone goes to the hospital, they're in a coma for 25 days, they die on day 26, you have to contact OSHA. If they die 45 days later, you don't have to contact OSHA unless there's another requirement. Now, I put in there generally. There's a couple exceptions to that rule. Those exceptions being if the worker was going from point A to point B and they were driving on a public roadway, so they get into a fatal accident on the roads, that would not be a situation that you would have to report. Or if they were taking public transit, so they were on an airplane, they were on a bus, there was a crash, fatality that happens that way, that's not something that's ultimately reportable. But if you have an otherwise work-related death that happens, it has to be reported. So Wendy, I'm going to ask you this question. Let's say that you have an employee that gets into an accident at work, they die, and let's say it's within 40 days they end up dying. Is that something that would have to be reported to OSHA?
They die within 40 days?
Yeah, within 40. It does. So let's say it's day 40.
Day 40, you just have to report it.
Right.
But day 30, you should day 29.
Only if they die within that 40-day time frame. So if they have like some sort of complications that result from it, you wouldn't have to. The other ones that I'm going to tell you about here have a 24-hour reporting time frame. So once again, this is where you have to call OSHA or you have to go to OSHA's website and tell them all about what happened. And this has to do within 24 hours of an amputation. An amputation would be things like losing a finger, losing an arm, that sort of thing, losing a toe, losing a foot. That has to be reported to OSHA within 24 hours. Loss of an eye or loss of part of your eye, not just blindness, but actually losing part of your eye, that has to be reported to OSHA within 24 hours. Here's one that deals with inpatient hospitalization. So you have someone that gets into a bad accident, they go to the emergency room, they're ultimately admitted to inpatient hospitalization. That has to be reported to OSHA within 24 hours. Now there's kind of a trick here with that one, per the rule, because you really, from a best practice standpoint, you only want to report to OSHA if you have to report to OSHA, right? So you don't want to call OSHA when you don't have to and report that an injury happened. You only want to do it when you have to. So the one thing that you have to keep in mind is that if you have an employee that gets injured and they go to the emergency room, that's not necessarily reportable, because the emergency room itself is outpatient. Okay, it's not inpatient. They haven't been formally admitted to the hospital as an inpatient sort of injury. So lots of times, just because of how medical coding happens and how the transfers ultimately happen, if you have a really bad injury and someone is ultimately admitted for inpatient hospitalization, lots of times it will happen after that 24-hour time period. So you have to be very, very diligent in trying to get the information from the worker or from the hospital or from your workers' comp carrier or whoever you're using that's getting that information for the billing records and evaluating that and staying on top of it, because if they are formally admitted to the hospital within the 24 hours, you have to notify them at that point. So that's for reportable injuries. When it comes to recordable injuries, There are certain forms that OSHA has that you have to record these injuries on. They're work-related injuries or illnesses that result in fatalities, days away from work, a job transfer or restriction, medical treatment beyond first aid, and I'll talk about first aid here in a little bit. Some sort of disease that's chronic. It could be cancer. It could be a fractured or cracked bone, losing a tooth, a punctured eardrum. And there's also some special recording criteria for some of those, including needle sticks and sharp injuries. So, talking about first aid, what is it? It's using a non-prescription medication. Okay, so if you're giving your employee Tylenol because they have a headache or because they have some sort of muscle ache, you're giving them ibuprofen or something along those lines, that's considered to be first aid. Okay, that's not necessarily something that you have to record. Okay, it's something that has to be beyond first aid. Administering tetanus is first aid. Cleaning, flushing, or soaking surface wounds is first aid. Using wound coverings, Band-Aids, those sorts of things, those are considered to be first aid. You don't necessarily have to record it because of those things. There are some pretty important distinctions to those rules, and you really need to know the rules inside and out before you put it on your OSHA log, because if it doesn't fit squarely within that rule, it might still be considered beyond first aid. So think about that super glue sort of material that you can use when you get a cut on your finger. That doesn't necessarily qualify as a wrap or a bandage, and therefore if you do administer it, that's considered to be beyond first aid. So you need to know that and be prepared for that. Using hot or cold therapy is first aid. Draining fluid from a blister or nail is first aid. Drinking fluids for relief of heat stress, that is all major stuff that is considered to be first aid. If those are the only things that happen, it does not have to be recorded on the OSHA forms. So where do you record? What are the forms that I keep referencing? Well, there's the OSHA Form 301. Okay, the OSHA Form 301 is an incident report for each recordable incident. Okay, so when someone gets injured, there's certain forms that you have to fill out that talks about who the employee is, what happened, where it happened, why it happened, what sort of treatment that they received. It's an incident report. The next one is an OSHA Form 300. This is a log of all recordable events that happen over the course of a year. And I'll show you what these forms look like here in a second. Then there's the OSHA Form 300A. So this is the form that I mentioned before. Did you have that posted from February 1st through the end of April? Okay, and what this form is a summary of all injuries that happened the previous year that were recordable. Okay, so this is what the Form 301 looks like. That's the incident report. That's where you get the information, the specifics about what had happened. This is the OSHA Form 300. You'll see that there's a lot of spaces that are on there for recording the injuries, and ultimately you would log the injuries that happened for a specific year. So all the injuries from 2017 would go on here. For 2018, if you're filling it out in 2019, that would go on here. And it's asking different questions like, okay, well, was there a fatality? Was there an amputation? Were there days away from work? Were there job restrictions? Okay? And there's some tricks to filling these forms out too, because one of the questions they'll ask is if there was a job restriction or there were days that were missed from work, how many days do you put in there? And the maximum number of days that you would put in there is 180. And sometimes you may not know. It might be something that happened at the very end of the year. Let's say it was an accident that happened on December 30th. Okay? You're filling out your OSHA form in January, and you're getting that posted by February the 1st. So what do you do in that situation? How do you calculate the days? Because you don't even know what the days are going to be. The person might still be out. And all you can do is you can use your best estimate or guess based on the information that you have at that point. Maybe you have some information from the doctors that are indicating how long they expect the person's going to be out, and you use that information. And if it goes beyond 180, you cut it off at 180. Okay? There's also some tricks when you're filling this out to know number of days away from work or job restrictions. If someone has to go to the emergency room, and it's on that same day, but they're back at work the following day. They don't have any job restrictions whatsoever, so you're not making any accommodations for them. In that situation, it does not count as a day away from work. However, if they're missing the following day, or you give them some sort of job restriction because of the injury, they can't perform their job duty the way that they normally would, and you give them a restriction, that would be a day that you would ultimately have to log on the OSHA Form 300. So the 300A, that's the summary that you have to post from February the 1st through the end of the year. Now, with auto dealers, you have to have these forms unless you have 10 or fewer employees at your dealership. Okay? Not all auto dealers have to have these forms specifically, but if you have 10 or fewer employees, then you can ultimately get rid of that. Yep. Yeah, so that's a great question. So it kind of depends on how you're ultimately set up. So do you have kind of like a corporate location then, and then it's like they're all set up as kind of like different, but you have some of the same recording requirements? Yeah. It really depends on how you're set up. In some situations, you do have to keep that information, and you do have to keep the logs. In others, you don't. I mean, it really depends on whether or not there's common ownership with those, and if it's all the same ownership, you're going to need to keep the logs. I would suggest that even if you don't necessarily qualify for keeping the logs, that you keep the logs anyway. Because if OSHA ever comes on your site, and that's going to be one of the first things that they ask for, and it's showing that you're actually trying to comply, you're actually over-complying with what their rules are. So from a best business practice standpoint, keeping these logs are good. It's also good for you to keep the logs because you're also looking at the data and the analytics behind it, so you can start to see trends. So do I have a lot of slip and falls that are happening? Is there a lot of situations where maybe someone is getting burned by a chemical or something like that? Or are there different protections that we can put in place? So it's always good to keep these logs anyway. Okay? So what you need to know about these forms themselves is that when it comes to that incident report and to the log, if there's an injury that happens and it's recordable, okay, you need to make sure that that gets on those forms within 7 days. So you have a 7-day time frame to ultimately provide those. All forms must be retained for at least 5 years. Okay? So, and this is a common practice with OSHA. When OSHA comes on site and they ask for these forms, they will ultimately have a look back for a 5-year period. The 300A from the previous year, as I mentioned, has to be posted. And on a federal level, employers with 250 or more employees must electronically submit the 300A information to OSHA by a date certain. Now, I say that on a federal level because some states have a much lower requirement for that, and it requires that these documents be submitted to the state OSHA. So some financial considerations to keep in mind. The Department of Labor estimates that employers incur approximately $1 billion per week in direct losses due to workers' comp claims. Okay, so these are workplace injuries. OSHA issues citations 80% of the time that they come and they perform an inspection, and the average citation is approximately $10,000. There's no limit to the look-back period for repeat violations, and that's very important to know. This is why you never want to get cited by OSHA, because the reason why is because if you had an issue and that issue resurfaces 10 years later, they can use that prior citation against your business to go after you. And this has happened a number of times, even in the situation that we were talking about where you have multiple locations. They might look at what happened at the other location and say, hey, it happened at the other location, and I don't care if it didn't happen at this location, but you had it happen at that location, corporate should have known about it, and they'll use that as one of those look-back periods for the repeat violations. Here's a showing of what the penalties are. Yes? It's for the same issue. Yep. So when it comes to the types of violations, you have serious, other than serious, and posting requirements. So if you are required to keep those logs, for example, and you're not posting them and they come on site, it could be up to a $13,000 fine. What's also important to know about these fines is that every January they increase with inflation. So they continue just to keep going up and up and up. If it's a willful or a repeat violation, they can fine over $132,000 for that one incident. So that's why you never want to get cited by OSHA, because if you get cited again, it could be a very, very large fine. So when it comes to the fines, OSHA always produces a top 10 list every year that kind of talks about all the different fines that they're doing. I have gone and I've looked through the auto industry, and I've picked out the top 4 that I think really apply. And the first one is hazard communication. That's the top of it. There were over 4,500 fines in 2018 alone for hazard communication. And what hazard communication, the fines are for, it's not having a hazard communication plan. Okay. Now, hazard communication is, how do you communicate to your employees that they're interacting with dangerous chemicals, for example? Are you telling them that, you know, this liquid bottle that you have, that it's a certain type of hazardous chemical? Are you keeping safety data sheets, for example? The next thing that they fine you for with hazard communication is no effective information and training on hazardous chemicals. One of the very first things that OSHA will also do is they'll ask to meet with some of your employees in your presence, and they'll start asking them, okay, well, where do I find the safety data sheets for these chemicals? And that seems to be a hot topic with a lot of the fines that happen. The failure to maintain the safety data sheets, because it turns out lots of times you have chemicals that you don't have safety data sheets for. And we'll talk about safety data sheets more here in a little bit, and I'll kind of tell you exactly what those are. Failure to properly label the hazardous chemicals. That's the top fine too. So when I talk about the hazard communication and the right to know, it's basically that the employees have a right to know about the chemicals that they're exposed to in the workplace. And they have the right to know about this before they start conducting work for you. So in your service centers, there's all sorts of chemicals that they're exposed to that could cause eye injuries, that could cause skin injuries. They could inhale it. It could cause lung injuries. They have a right to know about these specific chemicals. And the safety data sheets that are produced for these chemicals, and the manufacturers do create safety data sheets, they'll provide information that has to be readily accessible to the employees. Okay, so it has to be in the work area where they're actually doing their work. These safety data sheets, they have to be maintained for 30 years. So if you were letting your employees use one product 15 years ago, you still have to maintain that safety data sheet. You can maintain it in an electronic format if you want. So if you have a portal for safety data sheets, that's fine. OSHA says that it can be on a computer program. It just has to be in the work area where the workers can ultimately obtain it. These safety data sheets are standardized. There's 16 sections to them, and I'll kind of run through those here just really quickly so you kind of understand what they are. So the first 3 sections of a safety data sheet kind of deal with the product themselves. You know, what is the product? What's the phone number so I can call the manufacturer? What are the types of chemicals that are in the product? The next one's very important, though, in Section 4, first aid measures. So if someone is exposed to the chemical and they have symptoms that are related to it, and the safety data sheet later does tell you what the symptoms would be if you're exposed, this talks about the first aid measures that need to be taken and the treatment that's required. Section 5 talks about firefighting measures. There's a lot of chemicals that one would interact with that are ultimately flammable. It talks about the extinguishing techniques that would need to be required. Another point of contention with OSHA is that OSHA has a lots of times when they come on site too, they'll want to look at your fire extinguishers. And if you're not inspecting your fire extinguishers monthly, you'll be in violation. And if you're not recharging those every year, you'll also be in violation. You should also always have extra fire extinguishers, because if you do use one, you need to automatically replace it, get the other one recharged. So Section 6 talks about accidental release measures. Okay, so this would be where maybe you have a thermostat that breaks. There's mercury that is now exposed. It could be a breathing hazard, lung hazard to people. Section 6 will talk about that and talk about the proper method for cleaning up. Section 7 is handling and storage. Very important. You need to know how to properly store these chemicals. There was a dealership in Alabama last year that had some employees that were actually using brake cleaner to clean the floors of the dealership, the service center there. Highly flammable liquids, and a fire broke out. And it broke out in the area where most of the chemicals were ultimately kept. This fire ended up getting out of control. 3 employees ended up dying. Okay, OSHA comes in. They, of course, cite them. Luckily, there were no criminal indictments that happened in that situation. Ultimately, the dealership settled with OSHA for a six-figure settlement. So this stuff can be pretty serious when it comes to properly storing. And lots of times when you're talking about flammable liquids, they want the stuff in a case locked away where it's in a fireproof sort of container. So if you do have an incident, you're not going to have that same issue that's ultimately repeating. Section 8 talks about exposure controls and personal protection. So personal protection equipment, or PPE, is a pretty common term with OSHA. They want to know what sort of materials you're providing to your employees that are protecting them. You know, is it gloves? Are they respirators? Are they, goggles? Those types of things. Section 9 and 10 deal kind of with the physical chemicals and their characteristics and their stabilities. Section 11 is pretty important. This is actually talking about the effects that it might have on a person. It will talk about the symptoms that you might see with someone that's been exposed. And then Section 12 through 16, there's a lot of information that's contained in there, but I find Section 4 and Section 11 to be very important information, obviously. Obviously, Section 1 is important because you need to know what the chemical is, but Sections 4 and 11, you're really dealing with, okay, someone's been exposed, it's had this effect on them, what are the measures to ultimately prevent them from being injured? I skipped ahead one there. Here's just a sample of what a safety data sheet would look like. This is just the first page. They're all kind of in the same standard format. The fonts are always different depending on who the supplier is. Here's one that's from PPG that was a paint thinner. But those are kind of what the safety data sheets look like. And once again, you have to keep an updated safety data sheet binder for your employees at the dealership where they can easily access it, and it has to be in their work area. And it could either be a physical file, like I said, or it can be in a computer portal also. So hazard communication, I think your biggest areas for concern, besides what we just talked about, are things like eye wash stations. You need to make sure that these eye wash stations from a federal level are within 10 seconds or 55 feet of the work area. And that way, if someone gets something in their eyes, they can ultimately go, they can flush it out. Right to know, they need to know exactly what they're ultimately being exposed to. Labeling, lots of times you'll see different containers that are being used with fluids that are in them. Don't know what it is. The techs know what they are, but it's not labeled. OSHA comes in, they see that, and ultimately they'll cite you for it. First aid kits, make sure that you have your first aid kits with all the proper bandages and everything else that go into it. So the next thing that you're seeing a lot of citations from OSHA for respiratory protection. There were over 3,000 violations or citations that happened just last year. And this is things like failing to do an assessment to determine what sort of respirator people might need, if they need it, okay? Going through that process. Failure to have a written respiratory protection program. That's another thing that businesses and dealerships will get cited for. And failure to annually go through the assessment again and retest and just make sure that things are fitting properly. Another thing that's not on here is storage of these. Lots of times you'll get the respirators that kind of have like the dual filters in there, and there's a large suggestion that you keep those in like a large Ziploc bag so the filters ultimately don't get contaminated. Machine guarding is also a very big cause for citations, nearly 2,000 violations in 2018 alone. And the method of machine guarding might be the reason why there's the citation. Maybe just the machine guard itself just wasn't good enough. Or the point of operation exposes the employee to an injury without guarding. Or maybe the machine itself is not secure to the floor. So you might have a machine that's top heavy, it falls over on someone, they get injured, maybe just by it falling, or maybe because it has a blade or something else that's affixed to it. Or guard's not affixed to the machines. Okay, someone's taken off the guard because they think it's going to be able to allow them to perform their job much faster. Okay, that's a big issue. When I first started practicing law in 2002, kind of in my locale, there was a factory that produced bread, and this factory had a machine that was in there. They took a guard off. It was allowing the workers to kind of do their job faster. Guy puts his arm through the machine, loses half of his arm. Okay, $6.5 million verdict by the plaintiff against the business, in addition to the workers' comp, and in addition to the citations that ultimately happened. So making sure that the proper guards are in place is very important. So the next issue for citations are usually personal protective equipment. If OSHA comes on site and they see, okay, well, I'm in a shop, you guys are doing grindings, you're doing different things, you're not wearing your safety goggles, that's going to be ultimately a violation. So any sort of eye or face protection that's not used when employees at risk of eye or face hazards, that would be a citation. No use of eye protection. If they have prescription glasses and maybe they can't wear their prescription glasses because the goggles won't fit over them, that could be a citation too. You obviously want your employees to be able to see while they're wearing their PPE. So necessities. You need to make sure that you have the necessary plans in place. Okay, you need to make sure that you have written plans. You need to document them. You need to go through these assessments. You need to have a HAZCOM policy. You need to have a respiratory policy. You need to have a PPE policy. You need to make sure that you're doing these things and that you're ultimately amending them and enhancing the plans as you're kind of working. It's a living document. So your employees are going to be exposed at different points in time to different things, and so you're going to have to amend your plans and make sure that they're properly in place. The other thing that you should consider are third parties. Find subject matter experts that can help you with the ever-changing regulatory environment. From a dealership perspective, you want to sell and service cars, right? You don't want to worry about compliance necessarily. Allow someone to come in, help you with that process, take the bull by the horns. You don't have to. It doesn't hurt though, because we all know that the rules are ever-changing. The regulators keep changing what you have to do, and the requirements keep getting more and more stringent. So you need to have someone in your back pocket. Maybe it's your attorney, maybe it's a compliance company, someone that's coming in and helping you with this process. It could be also your insurance company. Maybe your insurance company has a program in place that might help you through this. So that's pretty much it when it comes to OSHA and some of the main requirements for what you need to do and how you need to comply. What I would also employ or kind of tell you about is that if you're really focusing on your compliance program and you're taking steps to try to make sure that your company is a better risk and that you're not exposing your employees to injuries, you should be able to take that information and you should be able to take that to your insurance carrier and say, hey, insurance company, I'm doing all these things. I'm a better risk than the next guy. I should get some sort of preferred risk there, and I should get a savings on my premiums. But it really requires you having a focus on your compliance program and really understanding what you're doing from a compliance standpoint and really taking that information and ultimately leveraging it. So from a cost standpoint, everyone thinks, oh, well, I don't want to do compliance because it takes so much time and it takes so much effort, and I might be bringing someone else in to ultimately help with it. But when you really think about that bottom line and the savings that you can have on your insurance premiums, it always makes sense. There's always an ROI to be had on that. So that kind of concludes my presentation. If anyone has any questions, please let me know. No one? Yes.
Okay, I'm completely not very OSHA. With like really a dealership, how does sort of like more off?
Yes, it could. It could be a consumer product. Okay. So when it comes to any sort of consumer product that you have, so not necessarily something that you're just getting from a vendor. If you're only using it in the same way that a consumer would, in the same frequency as a consumer, you don't necessarily have to have a safety data sheet for that. But if you're using it beyond what a reasonable consumer would, now it's no longer a consumer sort of use. Now it's a commercial use. And if you're using those as commercial use and it could be potentially dangerous to your employees, then you have to maintain those safety data sheets. That's a great question. Anybody else? Right. Yeah, so you need to make sure that those are all obviously properly stored. Obviously, when it comes to the fumes that are involved with that, you have to make sure that they're ultimately capped because those could go up right away. And you want to make sure that they're going to be put in a place where a car's not going to hit them, for example, or you don't want to have them just exposed out in the open. So you want to make sure that those are ultimately safely put away. Yep.
Yeah, and also shop rags. We have a guy come,
Absolutely.
not a working guy, but for
Yep.
this company that comes in and does a review, and one thing he pointed out to us last time, we had
Right.
canisters,
Right.
metal, and to cover to store our
Yep.
shop rags that we use to wipe down,
Yep.
brake solvents and stuff like that.
Yep. Yeah, and for most of those canisters, they'll require that you even have lids on those and that those canisters even be grounded so you don't have a risk of an explosion because of the fumes that are related to them. Okay? All right, well, thank you, everyone. I appreciate it. Thank you.